to the debrief, everyone. The Texas Parole Board has unanimously recommended that the governor there delay the execution of death row inmate Rodney Reed. Through layers of state and federal appeals, Reed's attorneys say he's innocent of the rape and murder of Stacey Stites in 1996. They say new witnesses, including the victim's relatives, admit Reed was in a consensual sexual relationship with Stites, and that explains the DNA evidence used to convict Reed. Reed initially claimed he did not know Stites, who was supposed to be married to a police officer who eventually wound up behind bars in another case. The defense says that fiancé, Jimmy Fennell, even confessed to killing Stites. The parole board recommends a 120-day reprieve. Reed's fate is now in the hands of Texas Governor Greg Abbott. Let's go straight to our experts. Forensic death examiner Joseph Scott Morgan. Several experts in the original trial 21 years ago are changing their testimony with motions filed by the defense. What are your thoughts on that?
Yeah, and in today's culture, and well, not culture, but in today's, with our technology that we have today and our understanding about things, I think that it's essential. What's it going to hurt to wait? That some of this evidence might be re-examined and take a new look at it. I think that it comes down to, they talked about the viability of the sperm that were recovered from her, and also kind of the measurements and the understanding of postmortem changes that had taken place in her body. So a lot of this is interesting. I'm still interested about that belt that may have been used as a ligature.
Yeah, I'm worried about that too. Former prosecutor turned criminal defense attorney Nicole Deborde in Houston. This is your state. This killing happened 2.5 hours west of you. Should this man be put to death or not?
Absolutely not. And it is such a reasonable ask that this defense team is asking for. They're saying, look, just wait. There's additional evidence that hasn't been tested. There is no reason to proceed with a very permanent death penalty resolution while we know that there is evidence yet to be tested. Why anybody would oppose this kind of a delay is beyond me. It's also unfortunate that it's taken a whole bunch of famous people screaming from the top of their lungs in a bipartisan political effort to finally get some attention for this. Otherwise, this man would be dying next week.
Yeah, exactly. Michael Bryant, quickly here. Reed lied about knowing Stites, and then his DNA winds up in her body. Now it's coming out that this was apparently consensual. Is the lie what sunk him in the trial, and is there another possible explanation for the lie other than that he killed her and he was trying to hide that fact?
I think if you go back 20 years, you got different cultural issues going on, different societal pressures. Maybe he just felt it was not the best idea to consent to a black and white relationship of a sexual nature.
Yeah, that's my opinion on it as well here. And look, you've got a fiance who's a cop. He could have been afraid of that too.
No doubt about it. I mean, there were a lot of pressures on him. Obviously, it didn't work out the way it should have. Hopefully now, a second look, a second chance, and there is no harm in putting
My opinion, I think this deserves a second chance as well. Let's move on now. The star witness for the defense has taken the stand in a Florida quadruple murder retrial. Prosecutors trying Henry Segura on charges he killed his girlfriend, Brandy Peters, their 3-year-old son, and Peters' twin 6-year-old daughters. The state says the motive was $20,000 in unpaid child support, which prevented Segura from getting a 6-figure job as a welder over in Afghanistan. But Segura says Peters was a drug mule who was killed by a cartel who caught her stealing money. The defense called an expert to go against the state's theory that victim Brandy Peters was pistol whipped. This crime scene reconstructionist says the injuries and the cast-off patterns of blood are consistent with Peters being beaten with a larger, heavier object.
One thing that's significant is the positioning of her body and the right arm. It would indicate that there was a prolonged struggle in this area, and she was moving to a certain point. And understanding the impacts or the number of blunt trauma injuries to the head and what they look like, and that you have depressions in the skull that are ovoid or rounded, would indicate that to create this type of spatter, these large drops here, it had to be some type of long, heavy object, baseball bat, a 2x4, something that had some mass to it, and the ability for the person to swing it hard. To create that kind of cast-off, that height, you would have to deliver a lot of force. And standing over somebody with a small, light object is not going to disperse that kind of volume of blood.
Prosecutors pushed back against this analysis, saying the defendant was a strong welder with a personal vendetta against the victim, enough to use this amount of overkill.
A baseball bat is an example.
Or type of.
It's type of something that has a large mass and that has some weight to it.
Baseball bats are 28 ounces, 26 ounces, something along those lines. Firearms are roughly going to be the same weight, are they not?
I've never weighed them, but I would think they may be close, depending on what type of you're talking about. But the other thing is, somebody holding a revolver or a pistol versus standing back, the dynamics of hitting somebody close up, even if you're exerting a lot of pressure, you're blocking some of that blood. Okay, your hand is here. The baseball bat or whatever the large object would be, you would be back away from it, and you're being able to apply more power.
Okay, fair enough. But you would also agree with me that you could also do it with the 4-foot or 3-foot arc with your arm if you're angry in a personal manner.
Well, the thing is you're going to have to be down on your hands and knees if the person's down there.
Sure.
It's not something with a baseball bat you're standing up and you're putting your full weight behind it. With a firearm, you're going to be on your knees and you can't deliver the same amount of energy, I don't believe.
Let's go straight now to forensic death examiner Joseph Scott Morgan. Joseph, you're the professor. You are our expert, our disinterested person. What's your analysis of that testimony?
You know, he was discounting the pistol whipping. One of the things that I found quite interesting during the forensic pathology testimony sometime back was that Miss Peters had these little kind of L-shaped lacerations that were very specific, and they were surrounding this large kind of depressed skull fracture that she had in the midline of her forehead. Those are going to require kind of a sharp edge to generate that, an edge that many times you might find with a firearm. And I've worked many cases where people have been pistol whipped, and not just pistol whipped, but pistol whipped to death. And so you can't completely exclude that relative to this. Now, that doesn't necessarily mean that Henry Segura did it. It does mean that there was a lot of anger involved in this, because this is up close, Aaron, and personal. The many times that she was struck, all of these injuries that she sustained, it certainly bears close examination.
Joseph Scott Morgan clarifying all of that evidence for us right now. Trial procedure hit a few road bumps today. The defense case is on hold because a witness isn't available until Monday. So the state began its rebuttal case. One witness was a police officer who tried to disprove what Segura said on the witness stand. To connect the dots, let's listen to how Segura described whether or not he was at home with the victims the day they were killed.
I don't know if I know her last name is Johnson. She was the investigator on the case. She was in the second interview.
Okay.
She called my phone numerous times, and she told me she already knew about me cheating on my wife, and she already knew about the girlfriend. So what was I supposed to tell her?
Well, did you tell her the truth? Did you tell her I was over there just because to see my son, but I lied to you about the sex? You didn't tell him that?
No, I didn't tell her that.
Okay.
I didn't have a chance to.
Why not?
Because the way our conversation went, the phone call ended abruptly, and I didn't call her back.
Okay.
And every time she called me, I would refuse to call.
And so your answer is no, that you did not tell police that.
Yes, I told the lady Johnson, investigator Johnson,
You told
over
her
the phone that I was cheating on my wife. I didn't want y'all to find out. Like I say, she went back and forth, and we was arguing about, she know I killed my son. We're gonna arrest you for killing your son, and I hung up on her.
So your testimony is that you told police in this case over the phone.
Investigator Johnson.
Wait a minute, don't interrupt her question, Mr. Segura. Let her finish her question.
She's asking the same question over and over.
Be quiet.
No, she's...
Be quiet.
Police investigator Anne Marie Johnson began the state's rebuttal. She says she started by telling Segura that a paternity test proved Javante was indeed his son. Here is how that witness describes the rest of that phone call.
If I remember correctly, he just stayed quiet with regards to that portion of it.
Okay. And then what did you say?
I said, so how does it feel to know that you killed your biological son?
And what did he say?
He said something to the effect of, what evidence do you have to prove that?
And then did he hang up on you at that point?
Yes.
Fair to say, if he had ever told anyone, any of the investigators, that he was actually at this victim's house the day that the murders happened, that's something that you would know?
Yes.
That would have been a change, a huge change from what he said in his November 20th and November 30th interviews, right?
Correct.
Have you ever heard of him ever admitting to anyone that he was at Brandy Peters' house the day of these murders, at any time, for any reason?
No.
Prosecutors say only the real killer could have known the children were found stacked in their bathtub because police didn't immediately release that information. The officer who interviewed Segura immediately after the bodies were found says Henry Segura never asked how the kids died.
It is the most important case in my career.
Okay. If he had ever told you in that November 20th interview that I've got the transcript for right here and that you've read several times, that these children were drowned, found in the tub, anything like that, that would be reflected in there. That would be on the video that you watched. That would be in your memory, right?
Of course.
And he never asked how they died, and you never told them how they died, right?
That's correct.
He never asked where they were found. You never told them where they were found, right?
That's correct.
And what he said that, what he told you that he knew coming into that interview was that his hairdresser, Pint, told him that Brandy and the two girls, the twins, were found dead in the home and that Javante was missing. And then when he arrived at Pint's house, that Pint then told him, I heard that they found Javante too and he's dead.
That's correct.
The jury has to figure out if that testimony is truthful, perhaps by asking, did Henry Segura not ask how his son died because he already knew? Is he the real killer as the state claims or not? Listen to this police interview with the defendant and decide for yourself.
The girl braiding my hair, her daughter, is some girl that lives next door to Brandy's, her guard mom or something like that. So she said that Brandy's mom and them came over to their house and told them this morning. When I called her about getting my son's hair, she told me.
Okay, what'd she tell you?
That Brandy and the kids, someone killed him this morning.
Javante is in the house.
He was in the house. He in the house? Well, I mean, he was in the house, found in the house.
He's in the house.
Yeah.
And I'm sorry to tell you, but he has passed away.
Yeah, she told me that they found the girls and the boy wasn't in the house. They think that he's with his dad or some guy she's claiming was his dad or something. So when the girl Pint, who's doing my son's hair, then when I went back over there, she said, no, they did find him in the house. How was he killed?
I don't know yet. I mean, this is going to be a long, drawn-out investigation.
Attorneys Michael Bryant and Nicole Deborde here now to discuss this case. So, Nicole, what's going on here with this? Did this guy know about the bodies, where they were located, because he's the one who did it? Or did he find out about it from the police? Or did he find out about it from somebody else who was there near the scene and was guessing, ambulances rolling up, no people coming out for treatment, connect the dots? I mean, is there really something to this or not?
I think it's just outrageous and heartbreaking. You're seeing this dad learn about this child's death for the first time on this video. And then you hear the police officer who is supposed to be responsible for giving the jury the correct information about how this person came to know this information. He's telling them a total lie. And certainly it's a lie because these officers have so much responsibility before they ever take the stand in a case like this to review the evidence that they're going to talk about it. And you can be sure that he reviewed that interview before he took the stand in front of that jury, and he lied about it. And now this jury is going to get to decide whether they believe what that officer has to say.
So you got a pretty harsh opinion on this, Nicole. Michael Bryant, you listened to it. What do you think was said there? Was the officer way too cocky in the way he responded to the question?
He really felt, it seemed to me, that he didn't do it. It's almost like he didn't see the interview played back, I'm sure, dozens of times. Why would he go so far as to commit so assuredly that that conversation never happened? I think that's crazy. We know there's sort of a predisposition in this case to rag on the authorities and the prosecution. Why are they bringing this case? What are they missing in the investigation? They knew where they wanted to lead, and anything that took them off that track they ignored. I think this kind of mistake in testimony or recollection of what happened is part of that big process that this jury is going to have to deal with.
Now, the state has to prove this case beyond a reasonable doubt. We're still waiting to see what comes next. And still ahead tonight, a last-minute attempt by the state of Ohio to delay a trial in the killings of 8 people in Pike County. Plus, The testimony is in, and now a judge must determine whether to admit or to suppress evidence against the accused killer of Iowa college student Molly Tibbetts. Those cases and more are after this break. A federal jury today convicted political operative Roger Stone in a case which connected to the investigation of special counsel Robert Mueller. Stone now faces sentencing in February on all 7 counts, including obstruction, witness tampering, and making false statements. He faces up to 20 years in prison. He's 67 years old right now. Law and crime analyst Gene Rossi is a former federal prosecutor. He reacted this way.
It is a resounding victory for the U.S. Department of Justice. That's number one. Number two, what it proved is that Roger Stone was a pathological liar, truly, because he had 5 counts of false statements or perjury, a pathological liar regarding his being the point of contact between the President of the United States and his campaign and WikiLeaks and getting dirt published regarding Hillary Clinton and the DNC. When Marie Yovanovitch is testifying about the Ukraine issue, of all the days to have Roger Stone found guilty of 7 out of 7 counts, it's not a good day for 1600 Pennsylvania Avenue.
Local cases now. An Ohio judge is refusing to delay a trial we plan to bring you right here next week. 8 members of the Roden and Gilley families were killed in the so-called Pike County massacre. They had been shot to death at 4 different homes. Sometime later, authorities arrested 6 members of 2 other families. The state has tried to delay the case against Rita Jo Newcomb 3 times. She's one of 2 grandmothers charged indirectly in the killings. This time, the judge denied the state's request to delay the case after complaints from the defense that it's ready to go. It's the defendant, of course, who has the right to a speedy trial. And no decision yet from an Iowa judge on what evidence will and will not be thrown out of court in the case of a murdered college student. Prosecutors say Christian Bahena Rivera confessed to arguing with Molly Tibbetts, confessed that there was blood, confessed to putting her body in corn, and took officers to where he dumped the body. But the state admits all of those statements came after a botched attempt to read Rivera his Miranda rights. He did, however, receive a second full Miranda warning, and what he said later will likely come into the case. Plus, Rivera allowed authorities to search his car before he was in custody, so it's almost certain that evidence of Tibbetts' blood and DNA in that car will be allowed into the trial.
I spoke with Mr. Rivera, asked him about consent to search the 2 vehicles. I explained the forms to him. They were the exact same forms. And then I provided the form to Mr. Rivera to read himself in Spanish.
Did he appear to read the form?
Yes, he did.
On that form, is there an indication that he has the right to refuse consent?
Yes, there is. That whole part talks about the right to refuse, his rights, constitutional rights to refuse the search, and that he's not being forced to agree to this. He agreed that the DCI agents could search the Altima. He also agreed that they could search the 2010 black Chevy Malibu, which was located at his trailer.
The defense says Christian Rivera's family showed up at the police station and asked about getting an attorney. An officer, the defense says, tricked the family into thinking he did not need one and even would be going home soon. Here's one of the defendant's relatives speaking through an interpreter.
What did she tell you?
Cuando ella llegó, saludó, buenas noches.
She greeted us, good evening, and then she asked us if we were Christian's family. We said yes. And then I said to her, we've been waiting here for several hours. No one has given us any information or spoken to us, and I want to know if we need to call an attorney or someone.
Did the woman give you an answer to that?
Sí.
Yes.
What did she say?
Ella dijo, oh no.
She said, oh no, we're on the last round of questions, and in 10 or 15 minutes, he's going to leave.
So you were made to believe that your nephew would be returned to you quickly. Is that right?
Sí.
Yes.
All sorts of trickery at play here. The defense also argues that it was unfair for authorities to keep Rivera awake for more than 24 hours during his interrogation. He'd been working at a farm all day before police showed up to speak with him, and he was awake all night being questioned. Let's go back to our experts now. Joseph, the state says someone would have inevitably found Molly Tibbetts' body anyway. It was above ground. It was not buried below the dirt, but it was buried under corn leaves in the summer. Would a searcher or a farmer have inevitably found it?
Yeah, I think that the possibility certainly exists here, and this is not something that's too far-fetched. Harvest season would be coming along very shortly, and they would have been bringing in the crop, and not to mention just day-to-day maintenance or weekly maintenance in that environment. So yeah, and there were a lot of boots on the ground throughout this process. We had state people, we had feds, there were all manner of folks. I even think that they were using drones. Sooner or later, they probably would have found Molly's remains either way.
Yeah, and I hate to be gruesome here, Joseph, but you're the forensics expert. Would this body have decayed by that point a couple of months later at harvest season where it perhaps would not have been found?
Yeah, because you've got this very biotic environment that's got a lot of changes going on. There's a lot of little nasties that are kind of crawling around the soil. You've got a lot of heat. People don't think of Iowa being hot. It's very hot, and plus she's buried beneath the layer of these corn stalks and leaves. So yeah, she would have been significantly decomposed by that point in time.
Nicole, a good strategy here for the state to just admit that many of the statements should be suppressed. Is that going to work?
I think that's probably the smart thing to do. I mean, if you can try a clean case without questionable evidence, that's always the right choice. Why give the Court of Appeals a toehold to overturn a verdict when you don't need the evidence?
Yeah, Michael, it seems to me that this state will have enough here to try this guy on murder charges. I agree with the philosophy that the consent searches, in other words, which led to her blood, her DNA in the car, I think that's going to come in. I think that the statements in the middle, I think the state was wise to suppress them. And I think afterwards, anything said after the second Miranda warning or the first real one, I think that'll all come in too. I think that's probably going to be enough for a conviction unless there's something I don't know.
No, I think you're absolutely right. And believe me, the state would not be so willing to toss out part of what we said if they didn't have all the other stuff you mentioned.
Exactly. Michael, Bryant, Nicole, Deborde, Joseph, Scott, Moore, can appreciate your opinions here on the debrief. That's all we have for the night. It's Friday. We'll see you back here on Monday. Everybody have a good weekend.